proving a conspiracy against rights under the color of law using the rules of professional conduct and the code of judicial conduct. Your constitutional rights, use them or lose them.
Proving a conspiracy against rights under the color of law using the rules of professional conduct and code of judicial conduct. Now, I can't guarantee you that any judge or lawyer will live up to the rules or the codes. I've been trying to get them to do it for years. Sometimes it works, sometimes it doesn't. But for the most part, these are the laws within a court of law, the rules and the codes, and nobody abiding by them and enforcing them. Not abiding by them is misconduct. And reporting as misconduct is mandatory in both, and nobody reporting that misconduct creates a conspiracy against rights under the color of law. Okay, so let's go here first real quick.
Basically all over my body, everywhere.
See, conspiracy against rights
was nonstop.
Under the color of law
Is
supposed to say leads to conspiracy to commit murder.
45 minutes.
Okay, so that's a hospital report from Cermak Hospital, and that's in Cook County Jail. It's where the guards beat the life out of me. I just got convicted, and I was in court, and I was in the back, and I was pissed because all through the trial, I was denied my right to be heard by the judge. The judge told me, talk to your lawyer, but my lawyer's not going to tell the judge, hey, he's mad because I'm not communicating with him. I wasn't diligent in expediting litigation, et cetera, et cetera. So he's not going to. And then when I complained to the state's attorney, because I wasn't issued discovery, no matter how many times I demanded discovery, I wasn't given it. What were you going to do with it? They were making claims of injuries. I wanted to see the hospital reports. They wouldn't let me see nothing. Hospital reports, police reports. But later on, after I got out of prison, I'm surprised I survived that beating, by the way. That was a beating that was supposed to leave me for dead. But anyways, it's because I told my lawyer, he said, I said, oh man, this is bullshit, no quick and speedy trial. All you people tried to do was get me to plead guilty. And I said, wait till I go out there. So what could, possibly say? And that's when I brought up reporting misconduct is mandatory in both the rules of professional conduct and the code of judicial conduct. And he knew what that meant, that I knew about this conspiracy to deprive rights under the color of law. And that's all you really need are the rules and codes. This is my YouTube channel. I'm on TikTok and as unaccompanied adult, on Threads as unaccompanied adult, and Instagram. Instagram sends it to Threads and Facebook. And but this is my YouTube channel. So people, all these are your public servants, videos about your public servants violating the oath. These are violating the oath alone is deprivation of rights. And then there's the obligations of the oath that they deny. So there's a lot of laws there that they break. And then I give you the penalties for these laws they're breaking, and they know they're breaking these laws, and they know the penalties, and the problem is they're not holding each other accountable. Nobody's being charged. So no matter which way you turn, there's conspiracy against rights under the color of law. Okay, so some people used to think I was crazy. I was talking to this young man. He's trying to get child custody. He lost a lot of stuff, but I talked to him about the rules and the codes. And eventually talked to him about deprivation of rights, because I said, your attorney not doing any of this, that's deprivation of rights. He went over the rules and he was amazed. And then he went over the codes. He was even more amazed. And that guy could talk up a storm when he goes into court of law. He storms in there like Godzilla struck through Tokyo, talking like Denzel in Training Day. You motherfuckers. He is a badass. But see, that's because he took the time to read out not everything I suggested, but quite a few things. And the first thing he did was read the rules and the codes, and he figured this conspiracy to deprive rights under the color of law. He figured it out by himself. He called it a Ponzi scheme. I told him the mob ain't got shit on the court system. It's just that everybody does this. All right. So, a conspiracy to deprive rights under the color of law combines two key federal statutes: 18 U.S.C. 241, conspiracy against rights, and U.S.C. 242, deprivation of rights under the color of law. It occurs when two or more people agree to injure, harm, or threaten or harm someone in the free exercise of their constitutional rights, specifically using a governmental authority official power to carry out the act. And they didn't want me getting it on the record. So for years, since the 80s, I got a conviction, wrongful conviction in 79. I was trying to find the rules and the codes, and when I finally did, I was in prison. And when I said, none of this happened. What the hell? And that's how I put this together, the conspiracy against rights under the color of law. Simply by reading the rules and the codes and seeing violating the rules or the codes is misconduct. And any misconduct, it's mandatory to report. Nobody reports this misconduct. And why is nobody reporting this misconduct? Well, if one points out one, then they're going to have to point out the other. And everybody's going to have to point each other out for deprivation of rights, multiple counts of misconduct in the rules and the codes. And it's a house of cards. They go down like dominoes. So that's why they beat the life out of me and made sure I didn't say anything about it afterwards. And I didn't until I got out of prison. And it shouldn't even been a prison charge. Battery. It should have been. But there was a lot of disinformation from the state's attorney's office, my lawyer. And they knew I knew the truth. I even issued them the truth. They said that the judge said I just got out of prison. That should give me time because I just got out of prison and to commit a crime so quickly. But I had a minimus paper showing I did it. I was given a 6-year sentence, did 2 years and 10 months. And I got out in 81, and this was in 89 or 90, but still, and they got upset because I questioned the preponderance of evidence, because when it came down to it, the judge said there was none, so she had to go between my word and the plaintiff's word. The presumption of guilt. They had me locked up and gave me a bond for $75,000. I was sitting on the same tier with two guys on trial for murder and had $50,000 bonds. But when I get into my case, I want to go over exculpatory evidence, because you can have the state's attorney exonerate you based on exculpatory evidence. And I have exculpatory evidence, and it wasn't nothing new. One time I went to the state's attorney's office, and they told me, no, this is not new, and just because they didn't bring it up at trial, it's just because it's in the hospital reports and the police reports. They mentioned it, but nobody brought up what was actually in these reports. And what was testified in court contradicted what was, in the police reports and the hospital reports. So nothing added up. And then I got sued for the same matter, and they claimed it hadn't happened on the premises to which I lived. But in criminal court, she testified it was out on the walkway by the street, on a public walkway. Not private, public. And the stories didn't match up. They couldn't prove any of the injuries she claimed. It could easily been disproven. She said she had some kind of brain surgery or something, suffered a stroke, partial paralysis. And I knew she didn't, but nobody would give me the hospital report so I could prove it. My own attorneys, I had several different attorneys in my case, and the one I had originally, he got replaced unbeknownst to me, and I didn't know till one day I show up in court, and then this is my attorney. Who is this guy? Who are you? I don't know you. And he insisted that I take a plea, and he spent months and months trying to convince me, going through my family. He rarely talked to me, but he would go through my family, and he inflated the charges. Was telling the family that it was my ex-fiance, that she was dying, and I could go to jail for murder if she dies, and she's suffering. And no, she wasn't, and she wasn't in the hospital long enough. And when she got out, I have pictures of her at a bar, with a beer in her hand, and she's known for other party favors, and it mentions in the hospital reports. But I didn't get that till after I had to go pro se. I was being sued for the same thing, and I actually won on that. And that was using the rules and the codes, because the judge wasn't allowing for any witnesses, any evidence. I had the hospital reports, the police reports, and he said, no, we're going to go by what they went by in the other court, the conviction. I says, well, if you're going to go by that, what she testified to doesn't match up here. He says, no, that's, this is a different court. So everything was totally illegal, and everything violated the law. But, that was in the 90s. It was just me, and not a whole lot of people knew this. Not a whole lot of people knew this stuff that I knew, outside of lawyers and judges. So, seriously, I felt like it was me against the world. Okay, or harm someone free exercise of their constitutional rights, specifically using government authority or official power to carry out the act. Core and legal concepts under the color of law: acting or using the power of a government badge, office, or official position. Conspiracy: agreement between two or more people to commit an illegal act. Specific intent: the accused must act willfully to break or clearly establish federal or constitutional rights. And I can prove that with you, because it's not abiding by, enforcing, living up, the rules, the codes, that's violating the oath. And so it's easy to prove they didn't do that. We'll get to that. Penalties and punishments: standard violations, fines is up to 10 years in federal prison, bodily injury or kidnapping, imprisonment up to life, or death penalty if the violation results in death or specific aggravated acts. So if you go back and watch that video, you can see they tried to cave in my head, they caved in my groin, and I thought one day I'd get married, have kids, have a family. That never happened. Okay. So first, we're gonna go with the Code of Judicial Conduct and my right to be heard, because I'm gonna tell you what I would have told the judge. So Code of Judicial Conduct is set for ethical rules and guidelines that judges and judicial candidates must follow. Ensures courts stay fair, honest, and independent. Most states base theirs on the rules of American Bar Association, Code of Judicial Conduct, and the Code of Judicial Conduct for the United States. Okay. So we're going to go with that one. Okay, so the judge denied me my right to be heard. Matter of fact, my lawyer ran and told the judge, so the judge said, no court for this guy, and sheriffs took me to the elevator, down to the Tombs. That's where I thought I was going to die, in the Tombs, going from the court building back to the county jail. But that didn't happen until they got me back to the county jail. So anyways, they wind up not doing all this. So you can cite them for violating all this. So I'm going to have to come back. So, okay, Canon 2. So that's where we're going to go. Canon 2. Ensuring the right to be heard. Okay, so I have the right to be heard. Failure Uh, uh, to ensure that right to be heard would be a lack of competence, diligence, and cooperation. The external influences on the judge's conduct was them showing bias, prejudice for your attorney and the opposing party. You know, there was no impartiality or fairness because he was giving precedence to the precedence to his loyalties to the bar. You know, fellow members of the bar, the lawyers. You know, they're not going to admit that these lawyers and violated the rules of professional conduct, and it's their job to make sure nobody violates those rules. It's the job of all lawyers and judges to make sure nobody violates the rules or the codes. If they do, it's their duty to report that misconduct. Responsibility aside, okay, decorum, demeanor, communication with jurors. So right now we're just going to stick with ensuring the right to be heard and these other rules in Canon 2, okay? Because if she violates one rule from that canon, she winds up violating multiple rules, he or she. Okay, so 2.5, okay. A judge shall perform judicial duties, administrative duties competently and diligently. A judge shall cooperate with other judges and court officials in administration of business. Oh, that was diligence and competence. Okay, I'm sorry. Ensuring the right to be heard. A judge shall accord every person who has a legal interest in the proceeding or that person's lawyer the right to be heard. Okay? Let me reiterate that a judge shall accord to every person who has a legal interest in a proceeding or that person's lawyer. Now, the judge knew I was going to complain about the lawyer, but told me the only way she's going to listen to me is if I tell my lawyer to tell her what I want her to know. What the fuck? A judge may encourage parties to a proceeding and that their lawyers to settle matters in a dispute, but shall not act in a manner that coerces any party into a settlement. The judge in my eviction case forced me into an early resolution program, which is arbitration, and that basically get me to take an attorney, and that attorney I knew would be ineffective assistance to counsel for failure to abide by the rules of professional conduct and citing the opposing party for filing a fraudulent and frivolous claim. Okay, but you can say that about anybody. Okay, so the judge didn't give me my right to be heard and made sure I would be silenced forever. Okay, so responding to judicial and lawyer misconduct. Okay, so that's what I want to tell the judge. Do your job. A judge having knowledge that another judge has committed a violation of the Code of Judicial Conduct that raises a substantial question regarding the judge's honesty, trustworthiness, or fitness as a judge in other respects shall inform the proper authority. B. A judge having knowledge that a lawyer has committed a violation of the rules of professional conduct raises a substantial question regarding the lawyer's honesty, trustworthiness, or fitness as a lawyer in other respects shall inform the appropriate authorities. So that's what I wanted the judge to do, okay? But she didn't, so she wound up denying me my right to be heard. Okay, where is it? So, and, okay. Denying me my right to be heard was a lack of diligence, competence, breaking Rule 2.5, 2.4, 2.3, 2.2, 2.1, just Canon 2 almost in its entirety, And then 2.15, responding to lawyer, because she didn't want me to get that on the record. That's all. She didn't want me to get it on the record, and I've been trying to get it on court record since. So then they wind up violating Canon 1 as well, okay? Compliance with the law, promoting confidence in the judiciary, avoiding abuse of prestige of judicial office. So they violated Canon 2, so they violated Canon 1, right? Oh my goodness, they are really putting a hurting on you, okay? preamble and scope and terminology. Okay, so this sets the guidelines. Okay, so an independent, fair, and impartial judiciary is indispensable to our system of justice. The United States legal system is based upon the principle that independent, impartial, and competent judiciary. I'm going to laugh. Plus, this is kind of tiny. Let me expand it a little. The United States legal system is based on the principle that an independent, impartial, and competent judiciary composed of men and women of integrity will interpret and apply the law that governs our society. Thus, the judiciary plays a central role in preserving the principles of justice and the rule of law. You know what the penalties are for violating the rule of law? Not doing this is violating the rule of law. You know that, right? Look up the penalties for violating the rule of law. Adhere to the rules, respect and honor the judicial office as a public trust, meaning it's part of your trust fund. You know, public trust is part. You know, the land, the water, the air. That's the public trust fund. These are trustees. They're supposed to maintain this shit. All right. Strive to maintain. Strive to maintain and enhance confidence in the legal system. Judges should maintain the dignity of judicial office at all times and avoid both impropriety and the appearance of impropriety, like not driving around in big old mobile homes, in their professional and personal lives. That should aspire to all times and conduct that ensures greatest possible public confidence in the independence, integrity, impartiality, integrity, and competence. The model rules of Code of Judicial Conduct establish standard for ethical conduct for judges and judicial candidates. It is not intended as an exhaustive guide for conduct for judges and judicial candidates who are governed in their judicial or personal conduct. Well, anyways, you know, what happened to the preamble and scope? Why, and nobody want to do that. Okay, so that's judicial misconduct. Okay, so when you cite a conspiracy against rights under the color of law, first you want to cite judicial misconduct and how they violated the Code of Judicial Conduct. Okay, so that's not a whole lot you got to say. Okay, so that's deprivation of rights. Everybody gets a case of deprivation of rights. Okay. So that's just a judge. Okay. So preamble and the scope. And so we're gonna go to that too, because none of that happens. Okay. Okay, competence. Okay, so you're gonna use that. A lawyer shall provide competent representation to a client. Competent representation requires a legal knowledge, skill, thoroughness, and preparation reasonably necessary for the representation. I don't feel it was competent that this idiot spent almost a year trying to talk my family into me taking a plea deal. You know, and it would have been competent if he would have been diligent. Okay. A lawyer shall act with reasonable diligence and promptness in representing a client. Yeah, it would have been competent if he would have been diligent in communicating with you, right? Right? A lawyer shall promptly inform the client of any decision or circumstances with respect to which the client's informed consent, as defined in Rule 1.0e, is required by these rules. Reasonably consult with the client about the means by which the client's objectives are to be accomplished. So they can't do anything without your consent, without asking you, talking to you. But they'll do it anyway. They don't give a fuck about you. They don't give a fuck about the rules. They don't give a fuck about the oath. Keep the client reasonably informed about the status of the matter. Promptly comply with reasonable requests for information, like discovery. Consult with the client about any relevant information on the client's conduct when the lawyer knows that the client expects assistance not permitted by the rules of professional conduct or other law. A lawyer shall explain the matter to the extent reasonably necessary to permit the client to make informed decisions regarding the representation. So, it would have been, as I said, it would have been competent to be diligent to communicating with you. Let's see, what other issues? Like these fees. I mean, any fee is unreasonable if they aren't abiding by and enforcing the rules of professional conduct and the code of judicial conduct. So you might want to look on that. Lawyers shall not make an agreement for a change or collect an unreasonable fee for unreasonable amount of expenses. Factors to be considered determining the reasonableness of fee, including the following: time and labor required. Okay, so you're going to want to go through that. Everybody complains about fees. Conflict of interest. I've been seeing people talking about conflicts of interest. So, you're going to use the rules no matter what court you're in. You're going to need the rules and the codes. And this is how you can prove deprivation of rights. And it's got to start with your attorney. And you can also use the rules against the other attorney. And I'll show you in a moment. Okay. Oh, yes. Podcasting. It's almost the same. Former judge, arbitrator, client with decision-making limitations, and you could use that because, look at what it says. A lawyer, as far as reasonable possible, maintain an ordinary client relationship with the client with decision-making limitations, including when a client's decision-making impact the client's ability to provide direction for a lawyer to make. Okay, because that's basically how they're treating you. Like, you can't make decisions for your own. So use it, you could use that against them. Duties to a prospective client. So when you go to talk to lawyers, okay, advisor. Representing a client, lawyers shall exercise independent and professional judgment and render candid advice. In rendering advice, the lawyer may refer not only to law, but other considerations such as moral, economic, social, political factors that may be relevant to the client's situation. So remember, they're supposed to be an advisor. Meritorious claims and contentions. Like I said, they have to go, when they go to court, it's called the preponderance of evidence, and it mentions here. A lawyer should not bring forth or defend a proceeding or assert an issue therein unless there is a basis for law or fact for doing so that it is not frivolous, which includes a good faith argument for an extension, modification, or reversal of existing law. A lawyer for the defendant in a criminal proceeding or the respondent proceeding that could result in incarceration may nevertheless so defend the proceeding as to require every element of the case be established. So there must be meritorious claims and contentions. Nobody can come in there expediting litigation. Okay, so let's get into, they can't come in there and just make up shit, And the judge is supposed to make sure that they aren't coming in there on a wing and a prayer, thoughts and prayers, like those knuckleheads did. Lynn Wood, Sidney Powell, and all them. They got all their cases thrown out for saying the election got stolen. But there was no proof. All they brought were people's feelings. Facebook memes. Okay, so expediting litigation. Okay, lawyers shall make reasonable efforts to expedite litigation consistent with interests of the clients. So that would be diligent. So, that would be competent if they were diligent in expediting litigation, don't you think? Candid towards a tribunal. Okay. A lawyer shall not knowingly make false statement of fact or a law to a tribunal or fail to correct a false statement, material fact that the law previously made to a tribunal by the lawyer. Fail to disclose to the tribunal legal authority and the controlling jurisdiction known to the lawyer to be directly adverse to the position of the client and not disclosed by opposing counsel, or offer evidence the lawyer knows to be false. If a lawyer, the lawyer's client, or a witness called by the lawyer has offered material evidence the lawyer comes to know is falsity, the lawyer shall take reasonable remedies, measures, including necessary disclosure to the tribunal. A lawyer may refuse to offer evidence other than testimony of the defendant in a criminal matter the lawyer reasonably believes is false. And that's what the state's attorney did with me. She used testimony she knew was false, and if she would have gave me the hospital reports, my lawyers, there was different lawyers, or the judge they were supposed to make sure I obtained discovery. It's in the disclosure law. Look up disclosure law. That would require you to know this, but I'm going over you with you as well. Okay, a lawyer who respects a client and represent a client in adjudicated proceedings, who knows that a person intends to engage or is engaged in criminal fraudulent conduct-related proceedings, shall take reasonable remedy measures, including, if it's necessary, disclose to the tribunal. So if your lawyer knows you're going to break the law, he's got to tell the judge. The duties stated in paragraph A and B continue to the conclusion of proceedings and apply even if compliance requires disclosure of information otherwise protected by Rule 1.6. In ex parte proceedings, the lawyer shall inform a tribunal of all material facts known to the lawyer that will enable the tribunal to make an informed decision whether or not the facts are adverse. So in my eviction case, the lawyer withheld facts from the judge to get the judge to evict me. It came down I wasn't paying rent, and I was paying rent, and I could approve it, but they wouldn't let me because the judge didn't want evidence. She denied me my right to be heard and finally gave it to me after several months. Well, that wasn't being diligent. I mean, she violated the Code of Judicial Conduct in every way, and so did the opposing party. Their lack of meritorious claims and contentions, failure to expedite litigation, candor towards the tribunal, and fairness to the opposing party, who would have been, diligent, to present meritorious claims and contentions, or not to state anything adverse to such. Lawyers, like I told you, special responsibilities of the prosecutor. You could use that. They don't do that. You can get any prosecutor on this. Prosecutor in a criminal case shall refrain from prosecuting a charge that the prosecutor knows is not supported by probable cause. See that one judge in Texas? He's the one that's always throwing out those probable cause hearings and then yelling at the cop and the state's attorney, why are you doing this? Hey, walking while black, that's not against the law. And saying, well, he flinched, so we got him for resisting arrest. Well, that's natural instinct. You can't walk up to somebody and grab them and expect them not to flinch. That's not probable cause. It's for arrest. So that's why I used to go to courts and help people before this disabled thing, criminal courts, and I always tell people about asking for a probable cause hearing, because cops will arrest you without probable cause, and then you got to go to court and fight it. And they think it's a big joke because you got to get a lawyer, but if you demand a probable cause hearing, then they got to establish there was probable cause for arrest, and there rarely is. So I've helped a lot of people get cases thrown out on no probable cause, but the judge and the state's attorney didn't cite the officer for filing a false police report. There was no probable cause for arrest. It was proven here in a court of law. You broke the law. You violated the oath. You know what the penalties are for violating the oath? That's a federal offense. Not to extend from an unrepresented accused a waiver of important pretrial rights, such as the right to a preliminary hearing. When a cop arrested me, I knew my Miranda rights. I even gave him my Miranda rights. He said, those aren't mine, those are yours. I said, they're ours. But anyways, when I asked for my lawyer, he didn't call my lawyer. I didn't get my lawyer. And he brought in the state's attorney. And the state's attorney came in for confession, plea deal. and didn't tell me who she was. And she knows she's not supposed to talk to an unrepresented person or try to seek or obtain from an unrepresented accused a waiver of important pretrial rights, such as right to a preliminary hearing, or known as probable cause hearing. See, they just came in right away and wanted me to just sign some confession and waive all my rights and just say lock me up. No due process. I didn't even get a public defender, not yet alone my private attorney. Make timely disclosure to the defense all evidence, information known to the prosecutor tends to negate the guilt of the accused or mitigate the offense, and in connection with sentencing, disclose to the defense and to the tribunal all unprivileged mitigating information known to the prosecutor, except when the prosecutor is relieved of this responsibility by protective order of the tribunal. Not subpoena a lawyer. Okay. Okay, this is what I want to get to. Except for statements that are necessary to inform the public of the nature and the extent of prosecutor's action and serve a legitimate law enforcement purpose, refrain from making extrajudicial comments that have substantial likelihood in highlighting public condemnation of the accused, or exercise reasonable care to prevent investigative law enforcement personnel, employees, or other persons assisting or associated with the prosecutor in a criminal case from making an extrajudicial statement that the prosecutor would be prohibited from making under Rule 3.6 of this rule. Okay, here's what I want. A prosecutor knows of new, credible, and material evidence creating a reasonable likelihood that the convicted defendant did not commit or the offense which the defendant was convicted. The prosecutor shall promptly disclose that evidence to the appropriate court authority, or if the conviction was obtained in the prosecutor's jurisdiction, promptly disclose that evidence to the defendant unless the court authorizes delay, and undertake further investigation to make reasonable efforts to cause investigation to determine whether the defendant was convicted of an offense that the defendant did not commit. When a prosecutor knows of clear and convincing evidence establishing the defendant in the prosecutor's jurisdiction was convicted of an offense the defendant did not commit, the prosecutor shall seek to remedy that conviction. So there was a lot of people asking me, they had exculpatory evidence if I could help them, or if I knew of a good civil rights attorney. Take a shortcut. It's right here. Just make sure you don't go by yourself. You may not come back out. And try to get a whole lot of people in which you go over the rules of professional conduct, go over Rule 3.8, special responsibilities of the prosecutor, so everybody knows what you're up to. And then you're going to explain to them this conspiracy against rights under the color of law. Okay, dealing with unrepresented persons. In dealing with behalf of a client with a person who is not represented by counsel, lawyers shall not state or imply that the lawyer is disinterested. Okay, so they'll go to talk to you and act like, they don't care, but trying to pump you for information. Responsibilities of subordinate lawyer responsibilities regarding non-lawyer assistance. Even though these people say they're not lawyers, they can still be held in this conspiracy against rights under the color of the law. Okay. Ignorance of the law is no excuse. Just taking orders is no excuse in a court of law. Okay. So that didn't happen. Okay, what was that? 3.8, right? Truthful statements to others. I see a lot of you got where you could prove that lawyers and judges lie. Okay. Fail to disclose a material fact. Dealing with respect for third parties. Responsibility partners, managers, and supervisors. Unauthorized practice of law. Lawyers shall not practice law in a jurisdiction in violation of regulation in legal profession of jurisdiction or assist another in doing so. So a lawyer who is not admitted to practice in jurisdiction shall not. Well, if they're not playing by the rules or the codes, that's unauthorized practice of the law. And by the way, when you cite them for violating the rules and the codes, that's intentionally, knowingly, willingly, wantingly. There's no mistakes in violating the rules and codes. It's intentional. See, reporting professional misconduct. A lawyer who knows that another lawyer has committed a violation of the rules of professional conduct and raises a substantial question the lawyer's honesty, trustworthiness, or fitness as a lawyer in other respects shall inform the appropriate authorities or professional authority. Okay, reporting professional misconduct. So the state's attorney was supposed to report your lawyer was supposed to report the state's attorney, and they were supposed to report the judge. A lawyer who knows that a judge has committed a violation of applicable rules and code that raises a substantial question as to the judge's fitness for office shall inform the appropriate authority, which in Illinois would be the Illinois Judicial Inquiry Board. Okay, so the lawyers were supposed to report each other and the judge, and then in the Code of Judicial Conduct it told you the judge was supposed to report the lawyers, and the lawyers to the judge, and everybody's supposed to report each other for misconduct. It's mandatory. It's professional misconduct for a lawyer to violate or attempt to violate the rules of professional conduct and unknowingly assist or induce another to do so, or through the acts of another, commit a criminal act through effects adversely on a lawyer's honesty, trustworthiness, or fitness. Well, they violated the oath. They didn't do none of this. These are requirements of the oath. Each one of these is a constitutional violation, y'all. Okay? Commit a criminal act that reflects adversely on a lawyer's honesty, trustworthiness, or fitness as a lawyer in other respects. Not doing none of this is not being fit and honest, and it's criminal. Engage in conduct involving dishonesty, fraud, deceit, or misrepresentation. Well, not doing this is engaging in conduct involving dishonesty, fraud, deceit, and misrepresentation. It's deprivation of rights, and nobody reporting anybody else. This leads you to the conclusion this is a conspiracy. A conspiracy, y'all. Conspiracy against rights under the color of law. Engage in conduct is prejudicial to the administration of justice. Not telling you any of what I'm telling you right now is prejudicial to the administration of justice. That's why when you hear me say in the interest of justice, that's a mandatory in every court of law. Everything must be in the interest of justice. State or implied ability to influence improperly a government agency or official to achieve results by the meaning of violation of the rules of professional conduct or other law. That's the only way they can make any guarantees is by violating the rules or the codes or other laws. Not only assist a judge or judicial officer in conduct is a violation of applicable rules or judicial conduct or other law. Okay, so these are laws, people. A bunch of constitutional rights being violated here. Okay? Engage in conduct, the lawyer knows reasonably should know that it's harassment or discrimination on the basis of race, sex, religion, national origin, ethnicity, disability, age, sexual orientation, gender identity, marital status or socioeconomic status and conduct related to the practice of law. Okay, so like, that's not happening. You know, okay, so that's misconduct. Violating any of this is misconduct. Okay. So reporting professional misconduct is mandatory. They didn't report that misconduct, so that's misconduct. You can cite your attorney. You could tell, for failing to report the state's attorney for misconduct, for failing to report your attorney for misconduct. So it's okay. So there you go. That's proving a conspiracy against rights under the color of law. Lawyers and judges, when they take the oath, these are the requirements of the oath. The rules of professional conduct and the code of judicial conduct. Nobody's doing that, okay? So since they're not doing that, why don't you show a little competence, be diligent, and communicate the lack of meritorious claims and contentions. Okay, failure to expedite litigation, the lack of candor towards the tribunal, the lack of fairness to the opposing party, the lack of impartiality and decorum towards the tribunal, a total failure at the responsibilities of a prosecutor. See, so you're really going to have fun if you really think about it. See, I'm giving you the simplicities of the law, and that's where you win. Okay, and you can hold them to the letter of the law on this, and the letter of the law strictly requires all this be done word for word to the letter. Okay, so let's go to penalties for violating letter of the law. Penalties for violating the literal text, letter of the law, depend entirely on the specific situation broken and the severity of the offense. The punishments range from small monetary fines to community service for minor infractions up to steep civil penalties, lengthy imprisonment, or felony records for major criminal violations. A conspiracy against rights under the color of law, that's a serious violation, my friend. Infractions, small fines, no jail time. Misdemeanors, these are no infractions. Short jail stays, probation, or moderate fines. Felonies, years in state or federal prison, loss of certain civic rights. Civil penalties, large financial charges, or corrective orders levied against individuals or businesses. Factors impacting the penalty: intent, accidental breaches, violating the rules and the codes. That's not accidental, that's intentional, knowingly and willingly. Accidental breaches sometimes carry lesser fines or allow for penalty relief, while willful acts increase punishment. Harm, causing physical, financial, or social damage, raises the severity tier. Jurisdiction, local, state, and federal laws enforce different sentencing guidelines. Okay, so don't forget about the penalties for violating the letter of the law. So if them numbnuts try telling you, hey, that don't think what you think it means, in the legal context, this is how lawyers interpret it. They tell them, you know what the penalties are for violating the letter of the law? And then, I actually had, back in the day, copied it out of a book and made copies. I used to make copies of a lot of stuff. Not just the rules and the codes of professional conduct, not just the complaint forms and anything and everything. But remember, the penalties for violating the letter of the law, okay? In the spirit of the law, I use the letter of the law so that we all see, say, and hear the same thing so there's no misinterpretation. When a lawyer and judge spread misinformation, submit false acts, or use fake IA-generated case law and legal findings, they face severe professional discipline, financial monetary sanctions, contempt of court charges, and potential disbarment or removal from the bench. So yes, lawyers and judges lying go to jail. Okay. Misinformation, disinformation, lying. It's illegal for lawyers and judges to lie. And they can't even give the appearance of. Remember when I was going over in the preamble, but you should go over it yourself. The rules and the codes. Do like I do. Print out copies. Highlight issues that you want to discuss. Things that didn't happen. There's so much that didn't happen. And I just showed you it's easy to prove a conspiracy against rights under the color of law. You didn't even need evidence, did you? All right. So, I just went over with you a bunch of your constitutional rights. You didn't even know what they were. You didn't know what due process was, did you? You know you're guaranteed that. Quick and speedy trial, right? You know you're guaranteed that, right? But that never happens. You know how many people are in prison, are sitting behind bars waiting for a trial? Look at that. A speedy trial is a constitutional right under the Sixth Amendment, ensuring that criminal cases brought to trial without unnecessary delay. Under Federal Speedy Trial Act, indictments must happen within 30 days of arrest, and trials must start within 70 days. I was talking to a granny who was trying to help her grandson, and she was telling me about a whole lot of wrongs, so I told her about this. And they violated his quick and speedy trial, and they were basically trying to get him to confess and take a plea deal, and it was almost 2 years. Okay, constitutional protector. Sixth Amendment guarantees a speedy trial to prevent long jail stays before a verdict. Federal rules of speedy trial acts as a hard deadline for 30 days to charge and 70 days to try a federal case. State laws, local states use their own timelines. So when you look up a quick and speedy trial, it'll come up with what's in your state, but everybody doesn't do that. Okay. And if you get denied a quick and speedy trial, the case gets thrown out, dismissed. So if your case is beyond what the state limits, you can go into court and ask the case to be dismissed with prejudice for violating your right to a quick and speedy trial. Okay, but you're going to have to use the codes, because the judge is going to tell you, talk to your lawyer, and you're going to have to say, hey, I have the right to be heard. It's here in the Code of Judicial Conduct, your failure to give me my right to be heard, bias, and all those other codes I showed you are rules in the code, in Code 2, because when they violate one rule in Code 2, they wind up violating 4 or 5 others, and that winds up violating Code 1, and that's violating the preamble in its entirety. Okay, so it's easy to prove deprivation of rights on the judge, and them not citing your attorney for ineffective assistance of counsel, that's conspiracy against rights under the color of law. Your lawyer is breaking the law, and the judge is not locking them all up. In the 70s, I used to call them the super predators. That's why I don't like the Clintons. They coined the term super predators. And a lot of people went to prison because none of this stuff I'm telling you about right now in this video happened. They didn't have a quick and speedy trial. The preponderance of evidence was null and void. The presumption of innocence didn't exist. The presumption of guilt was from the point of arrest and everybody had to fight their way out. Everybody had to prove their innocence, and the state didn't have to prove the guilt. No, it's the other way around. Read the presumption of innocence. You're presumed innocent, and the state has to prove you're guilty. They do everything as backwards, okay? So if you go over all this stuff I've been telling you about, it's easy to prove a conspiracy against rights under the color of law, using the law, rules, professional conduct, code of judicial conduct, and a couple other things I threw at you here. Okay, but you'll find a lot more in all those other videos I post about. All right. I hope I made that clear and simple. Okay, throw that on a writ of certiorari and throw it at the state Supreme Court and the U.S. Supreme Court. Okay, throw that on a writ of habeas corpus, a motion to quash, ineffective assistance to counsel motion, whistleblower complaint, look up rules of professional conduct complaint form, fill that out. Look up code of judicial conduct complaint form, fill that out. Look up a conspiracy against rights under the color of law complaint form, and then fill that out. Take every avenue. I'm tired of people, which one? All of them. All of them. All right. Look up government agencies with civil rights divisions. There's a few of them, so approach all of them, state and federal civil rights divisions. Okay. Leave no stone unturned. And even if you're only doing it for yourself, you have to remember when you're going in there, you aren't going in there representing yourself. You're going in there demanding your constitutional rights. And when you get them back for you, you get them back for everybody else. What they took from one, they took from all. So just doing it for yourself, you'll be doing it, helping out the general public. Those that I don't know if you ever pledge of allegiance, but when I pledged allegiance to the flag, it was to what the flag represents, the United States Constitution, and who was written to serve and protect we, the people. I'm pro-Constitution, pro-rule of law. That's what I'm about. Apolitical. Pro-Constitution, pro-rule of law. That's what we're doing there, folks. I'm pro-we the people. The content of my character is the Constitution, which makes we the people the many pieces of my heart. My loyalty and my allegiance will always be to them first and foremost. When it comes to the Constitution, I'm the constitutionalist. And even the Supreme Court will tell you, any law repugnant to the United States Constitution is void, so said Thurgood Marshall. Thank you and good night. May your Creator always be with you and rain many blessings. I wish you a long life and good health.